And what's marking 2025 with respect to the CCPA is that we finally have some pretty substantial enforcement actions. And so, and that gives us, again, the reason that that's important is it shows that the board is working. They are fulfilling their stated purpose, and and it gives us guidelines as to what they are focusing on. And as we're working with clients, we're better able to tailor advice and, sort of work from that. So, but, unfortunately for these companies, and I'll discuss a little bit about what these enforcement actions have been. So the first one was in March of 2025. This was the first settlement of an enforcement action by the CPPA against a non-data broker. The allegations were excessive verification for consumers to exercise their CCPA rights, made it difficult for consumers to appoint agents, which again is a right granted to them under the CCPA. There was asymmetrical cookie management. There was a multi-step process to disable default cookies, and a lack of contractual documentation with third parties receiving personal information. And they were ordered to pay a fine exceeding $600,000 and to take remedial measures. Then the next enforcement action that we got was, not too long after, in May of 2025. This was the second major enforcement action. The allegations were inadequate oversight and configuration of rights management platform, resulting in failed processing of consumer requests. Again, requiring excessive information from consumers then, right, to process those requests, and requiring identity verification to opt out of the sale of personal information. And they were fined around $350,000. And then in July, we got this settlement action with respect to Healthline Media, which is a website publisher, right? The CCPA found that we had a failure of this online publisher to allow consumers to opt out of targeted advertising, and they were sharing data with third parties without the CCPA mandated privacy protections. And this settlement, and I guess, part of this also, and I think this was the justification with respect to the largest penalty to date, right, was that the sharing of information with third parties included data that suggested that a person may have a serious health condition. So the settlement in this case was for over $1.5 million. And there were very strong injunctive terms, again, a novel sort of, application, banning the company from engaging in these very specific types of data transmissions. And that's with respect to the sharing of information that could indicate that someone has a serious health condition, because they are searching for, or you have, with a sort of lead in of, you've just been diagnosed with X. And right, so what does this mean? So the implication there, the inferences that are drawn from that are that, someone does have that health condition, and that's why they're doing that research. So there's a trend, right? I mean, it's consumer, it's consumer opt-outs, right? Are you actually allowing consumers to exercise their rights that they were granted under the CCPA? So are you making it unduly difficult for them to exercise those rights, including opting out of the sale of data, verification, and so all of those things. There's clearly there is a view to enforcing cookies. And if you look and the sort of cookie management and those tools,